If there's disruption to your cash flow, directors should immediately consider turning their minds to two major issues. First issue is, can the business continue to trade through this disruption to cash flow based on conservative cash flow forecasts? So what we mean there is, by estimating expenses and costs to be at the higher end and revenues to be at the lower end, can your business continue to survive? The second consideration is, can the business meet all of its debts as and when they fall due? So the big challenge when you can't meet all of your debts as and when they fall due is potentially the business might be insolvent. So if the answer to either of those questions is no, then you should speak to a qualified insolvency practitioner at the earliest opportunity. So an insolvency practitioner can help in a number of ways. The first way is an insolvency practitioner can help provide an assessment of insolvency risk to your business. So if you're unsure about whether or not your cash flows are sufficient to meet all of your debts as and when they fall due, an insolvency practitioner can provide a unique perspective, mainly from a cash mindset, as to whether or not the business can continue to trade through this difficult time. An insolvency practitioner can also help set out options to deal with unmanageable debt. They're uniquely placed to provide solutions to avoid insolvency and keep businesses trading through insolvent situations. And finally, insolvency practitioner can provide advice on personal liability to exposure. This is particularly important to directors of companies where they've signed personal guarantees and are at risk of being pursued personally for debts in certain circumstances like tax office director penalty notices. So the main risk for directors, if the business can't pay its debts, is insolvent trading. So the Corporations Act strictly prohibits insolvent trading. Directors can be held personally liable if they incur debts whilst their business is insolvent. There's huge personal liability risks for that. Now, the federal government has recently announced a temporary 6-month relief from insolvent trading. Now, on its face, this seems like a really good opportunity for directors to continue to trade out of difficulty. And it is. It's a very good opportunity. It gives directors time to work out the best solution for them in this difficult time. But what it doesn't provide is relief from the business's struggles or problems. It doesn't provide a solution if your business is trading insolvently. So it only protects the director from that point forward from liability for insolvent trading. If any debts have been incurred before that point in time, which is the 25th of March 2020, then those debts, if they've been incurred whilst the business has been insolvent, are not protected from personal liability. So the government has announced changes to the insolvency laws in response to COVID-19. The main changes, insofar as they affect companies and company directors, are by temporarily increasing the minimum debt to issue a creditor's statutory demand to $20,000. So this amount used to be $2,000. So what that means is, if you owe another entity, another company or an individual less than $20,000, that entity cannot issue a statutory demand against your company to pursue that debt. It means you can incur a slightly higher amount of debt before you're at risk of having a liquidator appointed by the court. But this is only for 6 months. Also, the time required to comply with a statutory demand has increased from 21 days to 6 months. So again, it provides more time for directors to deal with unmanageable debt, but it doesn't solve the problem of the debt itself. If you're concerned about your ability to see through the next few months of uncertainty, then you need to take action now. The best way to take action is to speak to an insolvency practitioner for peace of mind, or speak to your accountant. The earlier the better. The earlier you speak to an insolvency practitioner or your accountant about your cash flow challenges, the more options that might be available to you. You need to be realistic in your forecasts and in your expectations. So prepare conservative cash flow forecasts and don't expect to solve all of the problems in a short time frame. These things can take a long time to work through. William Buck's Restructuring and Insolvency team is very well placed to provide expert insolvency advice. on all the various types of formal and informal insolvency restructuring options. The general rule of thumb is the earlier that we get involved, the more likelihood we have of achieving the best outcome for our clients. And these outcomes don't always mean a formal insolvency solution. They can mean workouts, they can mean safe harbour, they can mean a better outcome than liquidation, and that's what we really try to achieve.